B101 is one of my absolute favorite contract documents to use when I'm negotiating agreements between architects and project owners. And that's true regardless of whether I'm representing the owner or the architect on the particular transaction. This is what I like to think of as the flagship owner-architect agreement that the AIA has published. This is not the most elaborate AIA agreement between owners and architects, and there's a couple that are simpler. I think that the B101 tends to be sort of the Goldilocks document. It's sort of the one that would be appropriate for certainly most commercial projects and some residential projects, although I could see some circumstances where a simpler AIA owner-architect agreement could be the choice on a residential project, unless it happens to be a massive one like some of the ones that I'm working on. And it's a good document for use on both public projects and private projects. This document assumes that the project delivery method that has been selected for the project is that the owner is going to have a separate contract with the architect and a separate contract with the constructor. All right, and this is the one that we're talking about right here. So this is the owner-architect agreement, and the owner is typically going to hire the architect first. So the B101-2017, or really any owner-architect agreement in this traditional method of project delivery where the contractor and the architect are going to have separate contractual arrangements leading up to the owner. This is a project delivery method where the general contractor is typically going to be selected later, right? So whether it is a design, bid, build method of project delivery where the design comes first and then there's a bidding exercise, or whether it's design, negotiate, build, where the design comes first and then the contract negotiation with constructors comes separate, this contract document, the B101-2017, is a good choice for this traditional method of project delivery where the owner is going to separately hire the architect and the contractor. The owner is going to hire the architect first, and the design is going to proceed in advance of a procurement stage where the contracts for construction are going to be let. So this is a sequential method of project delivery where the design is first, construction comes separate. There are other methods of project delivery discussed in many other videos that would allow for fast tracking or compressing of that timeline if we wanted design and construction to overlap a little bit more, if the owner was really interested in speed of delivery. But if the owner is interested in pursuing what I think is the most traditional method of project delivery, where they're going to have separate contractual relationships with the owner and the architect is going to owe its duty of loyalty to the owner and is going to be looking out for the owner's best interests in not just the design phase but the construction phase. This is a good contract document for that method of project delivery. The B101-2017 assumes that there is a single lead design professional on the project and that this is going to be the agreement between that lead design professional and the owner. It is assumed that that lead design professional is going to be the architect, but it doesn't necessarily have to be the case. It's not quite as simple as doing a search and replace to take the word architect out and to insert the word engineer in the event that you wish for the lead design professional to be an engineer, not an architect. There's a little more nuance than just that search and replace, but there's certainly nothing that would stop an engineer who is the lead design professional on the project that might subcontract out the architecture from using the B101-2017 to enter into its agreement with the owner. The B101-2017 assumes that there is going to be a number of distinct phases. First, SD, schematic design. Second, DD, design development. Third, there's going to typically be the creation of a permit set of drawings or construction documents. After that, we get to that procurement phase, which could be a bidding process to select contractors, or it could be a negotiation among a single selected contractor. And then CA, construction administration. But there's certainly nothing in the B101-2017 that would prevent an owner and an architect from customizing that scope of services. If it's a particularly large project, if it's a skyscraper, there might be room for there to be a concept design phase that's going to come before SD. Or if it's the sort of project where, for whatever reason, the owner is willing to forego the protection of the architect during the construction phase, there's certainly nothing that would prevent the B101-2017 from having the construction phase of services for the architect, construction administration, severed. So just because you've got this baseline understanding about what the scope of services is that the architect will provide, there's nothing that's going to prevent the owner and the architect from customizing. And what I like about the B101-2017, which I think is really, it's an excellent document for both owners and architects, because with only a few notable exceptions where I think custom edits are necessary, I do think that it's quite a fair document that tends to protect the interest of both. It sort of envisions that there is going to be this give and take between the architect and the owner over the design phase, where the architect helps to try to figure out what the owner's program is, and sort of holds the owner's hand throughout the design process. There's certainly nothing that says that the B101 could only be used by owners who are occasional or unsophisticated consumers of design services. Certainly the B101 is appropriate for project owners that are very sophisticated and very familiar with entering into owner-architect agreements. But one of the things I like about the B101 2017 is that if you are that large company that only occasionally hires architects and contractors, if you are, the real estate developer that is going to do, a job every couple years rather than a couple jobs every year, if you're that occasional consumer of design and construction services, the B101 2017 is a great option for owners, because it does have that sort of give and take with the architect, where the architect is going to really kind of hold the owner's hand through the design process and look out for their interest in the construction phase. I also like the B101 2017 because I think that it's a logical document for both owners and architects. It envisions a variety of different ways for the owner to compensate the architect. There's flexible compensation. It's compatible with an architect that might be paid on an hourly basis. It's compatible with an architect that is going to be paid a stipulated sum or a fixed fee for their basic services. But it is also possible for the architect to be compensated and have their fee pegged to a percentage of the cost of work that the owner incurs when they actually construct the building. Now, this last method of compensation for architects, I think, is the most complicated and risky for architects. So I'm not the biggest fan, if I'm an architect, of agreeing to take my fee as a percentage of the cost of the work, but it's frequently done. And if this is something that is important to the owner, or it's something that the architect is inclined to go along with, there are some custom edits for sure that a well-advised architect is going to put into the B101 2017 to protect them from that method of compensation. As I alluded to earlier, there's sort of like a sequence that the B101 2017 envisions the owner and the architect are going to go through. And this is a huge oversimplification, but essentially the owner is going to set a budget goal that the architect is trying to shoot for. And then the design is going to proceed. And then to make sure that the owner and the architect are not on very different pages when it comes to the evolution of the design and what it's going to cost, there is a pricing exercise baked into the B101 2017 at the end of SD, schematic design, at the end of DD, design development, and at the end of the construction documents phase and the bidding and procurement phase. And while this is a huge oversimplification, essentially what the idea here is that the architect is going to look at the owner's budget, they're going to look at their program, they're going to come to some basic understanding about what the building is going to be based on what the owner can afford, and then they're going to target through their SD and DD and CD phases that trying to hit that budget. But in the event that something happens that causes the budget to be exceeded, if the owner has scope creep, if they've got additional things that they're asking to be added to the project, or if there is some massive increase in commodity prices due to tariffs or one reason or another, you can maybe catch that at the pricing exercise at the end of SD or DD, and you can say, okay, we need to do a little something with the design, we have to scale it back, or the owner has to authorize an increase to the budget. And then the idea is that with this pricing exercise that plays out over the course of the entire design phase, the hope is that when you actually have a contractor on board, or you have an indication of the lowest qualified responsive bidder, if their bid is greatly in excess of what the owner wants to spend. And again, this is the oversimplification that I was alluding to a second ago. The basic idea is that the architect is going to value engineer the design without compensation. That's kind of what the architect gives up in order to try to bring the design back in line with what the owner's budget is. And then the give and take from the owner is that is going to be the extent of the architect's responsibility. So they do that VE for free. And the language in the B101-2017 isn't perfectly clear on this point, but the idea is basically that they can't be the target of a claim for over-designing as long as they go through this incremental process of design, check against the budget, design, check against the budget, design, check against the budget at the end of SD, DD, CDs. And then with that value engineering for free at the end, this is a great way that owners and architects can work together to try to make sure that they're on the same page, and that they wind up in construction with documents that the design professional issued for construction that are the kind that are likely to have a contractor commit to construct the project in line with the owner's budget goals. There are some things in the B101-2017 that are a tad confusing with regard to the distinction between what is a basic service for the architect and a supplemental service, because the 2017 version of the B101 introduces a third category, which is called supplemental services. And I think that we all know what basic services are, and we all know what additional services are, but supplemental services are something that a lot of people might scratch their head and say, what is that we're talking about? And to make a very long story very short, supplemental services are things that the architect hasn't agreed to provide as part of their basic services, but it is something that is on the menu. It's something that the architect is willing to offer if the owner raises their hand and they say that they want it. And the basic assumption is that the architect is going to be compensated on an hourly basis for those supplemental services in addition to their basic services fee. So one way to think about this would be almost like the same concept that you will find in owner-contractor agreements with alternates. These are alternates that an owner can accept if they wish, and there's a price associated with them. It's maybe not part of the basic scope of the contractor's work, but again, it's on the menu. And where it gets a little bit confusing with supplemental services is in Article 4 of the B101-2017, because there's a chart, it looks like a little matrix inside Article 4, and 99 times out of 100, most owners and architects are going to fill that chart out wrong. And I think that's very important in filling out that chart to be clear on who is going to be responsible for all of the different tasks in that chart. If there are some things that are not on the menu that architects are not willing to provide, like cost estimation services, it's got to be stated clearly there. And it's important to distinguish between what is a supplemental service, an additional service, and a basic service inside this chart. I think that most owners and architects don't understand how to use it, and they make mistakes in filling out the chart in a way that could come back to bite the both of them actually in a dispute, in the unfortunate event that one breaks out. One of the most important things to know about the B101-2017 is that it is always, always, always paired with the A201-2017 general conditions document. And I have many videos on the concept of the A201-2017 general conditions document. Some of them stretch on for 90 minutes. I think that probably the most watched video that I've created is on the A201 general conditions document, because I believe, without any real data, that it's the most ubiquitous contract document in the United States, certainly for construction projects, where you'll find it used on more U.S. construction projects probably than any other single contract document. And this is an agreement that is, or I should say that it is incorporated by reference into the B101-2017. You'll remember that I said at the beginning that the B101, the owner-architect agreement, is typically signed first before there's ever a contractor in the picture, right? So this A201-2017 document, which is relevant to not just the owner-architect agreement and incorporated in that document, it's also incorporated by reference into the owner-contractor agreement. And so you can imagine, it's the blinding flash of the obvious that if the architect is hired a year before the contractor, the owner and the architect are typically not going to vary the terms of the A201-2017 all that much, unless it is to sort of pair the assumptions in that document to make sure that the architect is not agreeing to more scope largely in the construction phase than they intend to provide. But for the most part, the A201-2017 general conditions document sort of sits in the background, and it is not typically negotiated between the owner and the architect. It does not call for a signature, and then when the contractor comes on board, there is typically a reevaluation of the terms of the basic A201-2017. The owner and the contractor, if everything goes in the way that the AIA envisions, may negotiate some edits to the standard off-the-shelf version, and then they would get the architect's blessing to those changes, if there is a good understanding of the need to have alignment between the owner, the architect, and the contractor on what this document says. And I've been making the point from the beginning of this video that this method of project delivery that we're talking about with the B101, this is an owner-architect agreement over here, and then we have an owner-contractor agreement over here. The general conditions document is sort of like the document that sits in between those two contracts. It's sort of like what fills out the triangle. And it is different than the owner-architect agreement and different than the owner-contractor agreement, because those documents tend to talk about what the business deal is between the owner and the architect. What are they going to do? What fee are they going to be paid? And the business deal between the owner and the contractor, what's their business deal? What's the scope of what the contractor is going to build? What's the definition of their work? What's their fee? The A201 general conditions document doesn't get into those business terms. Instead, it talks about how the contractor, the owner, and the architect are all going to play nicely in the sandbox together in this project, so that everybody's expectations are met. And the general conditions document doesn't call for a signature. It's incorporated by reference. And this is one of the reasons why there's a lot of confusion around it. Let me put it this way. If you're an owner and you hire an architect with a B101-2017, you are stuck with the A201 general conditions unless you delete that incorporation by reference of the general conditions, which would be an exceedingly bad idea, okay? Because the general conditions document has got 38 pages of essential terms, which again explain the way that the owner, the contractor, and the architect are going to play nicely in the sandbox together when they're working on the project. The word contractor appears more than 500 times in the general conditions. The word owner appears more than 400 times in the general conditions. And the word architect, or some variation of the same architecture, appears, I think it's 317 times in the A201 general conditions. So, really trying to drive this point home. If you're an owner and you're hiring an architect with a B101-2017, you better know that there's another 38 pages in the general conditions that are relevant. Same thing with an architect. If you're an architect and you're going to use the B101-2017, you better not fail to realize that the A201-2017 general conditions is incorporated by reference into your contract, even though you may not sign it, even though you may not see it, even though you may not negotiate it with the owner. And this is a good thing, because this is a document which explains, for example, that the architect is going to be essentially the guardian of the owner in the construction phase, right? So We all know that in CA, architects will make site observations, they will review RFIs, requests for information, they'll review submittals, they will review and bless contractor applications for payment, they will play a role in the punch list phase and then the certification of substantial and final completion. It's not necessarily the case that a contractor wishes to have the architect playing that role in the construction phase. A lot of contractors would prefer for the architect just to stamp the drawings and get the heck out of the way unless there is some issue, some very important submittal, some request for a change or substitution. And in order for the owner to enlist the protection of the architect in the construction phase, which is basically what the general conditions talks about, there has to be agreement with the contractor. And this general conditions document is the one in which the contractor says, okay, fine. I may not love it, but we'll let the architect thumbs up or thumbs down my request for payment. So there's critical terms in the general conditions document. As long as you're using an AIA contract, regardless of whether it is the B101-2017 or another, to hire the architect, and regardless of which contract form the owner uses to hire the contractor, if we have a situation where the owner up top here has a separate contract with the architect over here and a separate contract with the contractor over here, it is almost always the case that the general conditions document is going to apply unless we're using the handful of agreements where we assume that the architect either is not going to be involved at all in the construction phase, and then you'd have no need to incorporate by reference the general conditions, or in the event that you are using one of the AIA contracts, which is a little bit more of an empty shell in terms of what the architect's scope is, and it doesn't automatically make the assumption that the A201 general conditions is going to be a part of it, because again, that is really a document that talks about what's going to happen in the construction phase. And I mentioned it would be an exceedingly bad idea for owners and architects to try to get rid of the general conditions. Of course, you could just delete in your owner contractor agreement or your B101-2017, your owner architect agreement, you could delete the idea that the general conditions is going to govern. But what you're going to wind up with in that situation are contracts which have massive gaps in them. Article 11 of the general conditions talks about insurance, and it has essential terms that neither the contractor, the owner, or the architect can do without, just by way of one example. So it's important to understand that if you're going to use the B101-2017, if you're an architect, you got to be cognizant of the general conditions document, and that's true even if it's not negotiated at the time that you negotiate your B101 with the owner, and you very much have to have your ears open in the event that there is a negotiation between the owner and the contractor on that document after the design is produced and the contractor is selected, because what the owner and contractor do to vary the general conditions can be binding on the architect in certain circumstances with their consent. So it's just a point of paying attention for both owners and architects when they're negotiating a B101-2017. One of the things that I think is probably most important when I'm negotiating a B101-2017, and this is true regardless of whether I'm negotiating on behalf of one of my owner clients or an architect client, is the idea of keeping the owner-architect agreement insurable. In other words, that we not put words in the owner-architect agreement that will spoil the professional liability insurance of the architect. Off the shelf, the B101-2017 contains language which really ought to keep the architect covered by their professional liability insurance in the event that there is a claim. Of course, custom edits to the B101-2017 can take it outside the realm of insurability. If you would like to learn more about that, I've got other videos on this topic where we talk more deeply about insurability. But the big idea here is that the architect's professional liability insurance doesn't just protect the architect, it protects the owner, because if the owner has a legitimate claim against the architect, it's typically the architect's professional liability insurance that's going to step up and settle the owner's claim. And so it's an exceedingly foolish idea, in my view, if you're an owner, to destroy the architect's professional liability insurance with custom edits to the B101-2017 that are uninsurable. I think that's true with respect to all owner-architect agreements. I think that owners need to understand it's in their interest to have a contract that is going to cause the architect's professional liability insurer to respond in the event that there's a legitimate claim from the owner, and not have the insurance company say, sorry, architect and owner, you're on your own, because we've spoiled the insurance with the language of the contract. And of course, it's in the architect's interests as well, to not have the insurance spoiled. I like to joke that there are very few architecture firms that have a vault in the back of their office with, a couple million in cash or gold bars. Typically, the professional liability policy is the really only substantial asset that the architect is going to bring to the table to satisfy a claim, if there is one, a legitimate one from the owner for design malpractice. So whether I'm representing an owner or an architect, I am exceedingly focused on not allowing the dozen or so things that Owners Council often wishes to try to put into the document, because I want to make sure that if there's a claim, that I'm going to get the full benefit of the professional liability insurance. But in addition to the need to keep the document insurable and to try to not spoil it with custom edits, it's important to remember that any off-the-shelf agreement like the B101-2017, no matter how great of a document it is, it requires customization. That's true whether you're the architect or whether you're the owner. It requires customization that is specific to the parties and their relationship, that is specific to the project. There's usually an issue spotting exercise that I'm going to go through at the beginning of a contract negotiation, no matter who I'm representing. Are there, accessibility, Americans with Disabilities Act concerns? Are there hidden conditions? Is there asbestos? Are there tenants in the building that's going to be constructed on? Are we going to be digging near a property line? There's a lot of different project-specific and party-specific edits that I'm going to stick in to these to the B101-2017. I've got another video that talks about B101-2017 considerations for architects, and another one for owners, and I get a little bit more deeply into some of what that customization could be in some of those other videos. But you need those project and party specific edits, but you're also generally going to need edits around state specific issues. It is often the case that the state that the project is located in is going to have proscriptive and prescriptive requirements around payments. There may be prompt payment laws. There may be a Mechanics Lien Act that prescribes the paper that has to be exchanged by the parties as the project proceeds and the parties are paid. Typically, state law may put some constraints on how far a party can go in agreeing to indemnify or defend another party. So, there's absolutely the need to put project-specific, party-specific, state law-specific edits into the B101-2017, even though it's a fantastic document, because all contracts that are prepared by industry groups like the AIA, whether it's consensus docs or the EJCDC or the AIA, it's just a starting point for negotiations. So I would encourage my owner clients to think of the B101-2017 as a great option for them, with some notable exceptions where there is some very important customization that's required to make it a perfectly fair document. And when I represent architect clients, I'm delighted when they want to use a B101-2017. I think it's the flagship owner-architect agreement. I think it's great for architects. I think it's great for owners, as long as both parties go in with their eyes open and they make sure that they don't just take the document off the shelf, but they put in the custom edits that you need to put into the document, which is just a starting point for negotiations.